Teresa Phillips. I'm here with Kathryn Jones today. We both practice at Forster Bowman, but we practice in different areas. I primarily practice in probate, guardianship, and trust litigation, and some civil litigation matters. And Kathryn, you want to tell them what you do?
Sure, I do business transactions, some mergers, acquisitions, stock asset sales, and then I'll be the documents needed for the life cycle of business. So employment agreements, operating agreements, non-competes, and other documents that you may need while you're running your business. And then we also help you form them and then sell.
Okay, great. So let's see what we're going to be finding out about today. Let's take the webcam off so we won't distract you from the slides here. All right, today our seminar is Business and Incapacity, Protecting Small Businesses and Trust Assets from Guardianship Issues. If you've been watching any of our webinars lately, you know we've been focusing a lot on guardianship issues. So let's see what our agenda looks like today. We're going to go through an introduction, why we're having this seminar, why we thought it was a good idea to blend these issues, how we think incapacity, guardianship issues can affect especially small businesses and those trusts that have significant assets that need to be managed. We're going to start by looking at what is incapacity, how can it affect us, things of that sort. We'll go through what's common incapacity, contractual provisions that you either find in trust or operating agreements and things of that sort. We'll also go through some recommendations for better documents and to meet our clients' needs. And then finally, as always, we'll do a conclusion and have an opportunity for you to pose questions. Please feel free to do so. If we see any pop up during the session, we'll try to address them as we see them. If not, we'll definitely turn to that at the end of the webinar presentation. So these are some facts. These are some statistics that can show why this is an important issue to address. Kathryn and I both have discussed before, people are always focused on death and how a death of either a member or a partner, a trustee, things like that can affect their business or asset management strategy. But oftentimes people overlook incapacity. So statistically, a business officer or trustee is much more likely to experience incapacity rather than death while serving in those capacities. However, people typically do more to plan for death than incapacity. So that's why we thought it was a good idea to kind of focus in on this and kind of highlight how these issues are affecting folks. It's incorrect to assume incapacity is only related to a person's age. Disability can equal incapacity. Oftentimes people think this won't be an issue until they're later in age and they may start experience normal, memory problems or dementia. But you can have a disability from an illness, an accident, things of that sort, and that can happen, in your early 20s, 30s, 40s, prime years where you expect to be working and assuming a lot of responsibility. So during your working career, you are 3.5 more times likely to become disabled for at least 90 days than die. A 35-year-old has a 50% chance of becoming disabled for a 90-day period or longer before age 65. About 30% of Americans ages 35 to 65 will suffer a disability lasting at least 90 days during their working careers. A quarter of the world's people over the age of 25 will experience a debilitating stroke during their lifetime. In fact, at no point during your working career, that's usually deemed ages 25 to 65, will the chances of death be greater than disability. One of the reasons is medical care is better at preventing death, but maybe not so much as disability. I just realized, Kathryn, this is very depressing, some of these things that we're having to go through and some of these statistics, but it's the reality of what we have to deal with and more importantly, what our clients have to deal with. We have a chart here that's showing a trend, things that cause disability in earlier ages, such as hypertension, heart disease, cardiovascular disease, diabetes. While the statistical trend shows that the rate of death is going down, the rate of disability is going up a lot. You can see in all of those. And about 1 in 7 people ages 35 to 65 can expect to become disabled for 5 years or longer. Again, 1 in 7. So I think that those statistics kind of bring us to where we are and the purpose of our webinar. Through this discussion and review of the law and common practices, we hope to determine if our clients are indeed protected from the negative consequences of incapacity. which include if you have an issue with an incapacitated member or a principal in either your whatever your corporate structure is, or in the management of trust assets, you'll see that you can experience a disruption of operations. There's going to be uncertainty about the business or the management, and that can have and can lead to unproductive business. You can have unforeseen expenses. If someone's unable to perform their duties, there could be unforeseen legal expenses, unforeseen costs of doing business. Things have to be repeated. There has to be other employees or other people located who can maybe fill in the gaps there. There's a waste of assets oftentimes. If someone's incapacitated, they're forgetting or they're unable to appear and do the normal functions of their job. Assets can be wasted. Contracts can be lost. Business can be lost.
And this is often more acutely felt in the small business setting, where you may have 3 or 4 people, or maybe even just one person who's the backbone of the operation. And I know this isn't really a tax seminar, but one of the things that come to mind is in some businesses you have payroll tax obligations and reporting obligations that really one person has the familiarity with. And so, the IRS really isn't going to be super concerned on a personal level as to what happened to that person or why they're not fulfilling those obligations. But they will know if there's an obligation to file or pay missed. Other contexts also, and we'll talk about this later, credit agreements with banks, leases and landlords, things where you're having a third party, you're answering to a third party. If that third party is used to dealing with 1 or 2 people in the organization, there's going to be some transitioning and just adjustments once that person is no longer available in their full capacity.
And that kind of leads us into our last problem you can see with incapacity is in a lot of agreements, whether they be franchise agreements or creditor agreements, loan agreements you have, incapacity of a principal may be an event of default under that agreement. Oftentimes you'll see that in those kind of forms. So all those things can negatively affect the operations of a business or a trust, and that's part of our reasons here to look at these things and see how maybe we can plan for it or overcome it. So part 2, let's look at what is incapacity. What's the definition? And that's important because if you're going to talk about it in agreements, everybody needs to be on the same page as to what we're speaking of. There's a definition set forth in the Florida statutes under the Guardianship Code, Chapter 744.102, subsection 12. It's the definition of incapacity is, or an incapacitated person is someone who has been judicially determined to lack the capacity to manage at least some of their property or to meet at least some of the essential health and safety requirements of the person. Manage property means to take those actions necessary to obtain, administer, and dispose of real and personal property, intangible property, business property, benefits, and income. What does meet essential requirements for your health and safety mean? It means to take those actions necessary to provide the health care, food, shelter, clothing, personal hygiene, or other care without which serious and imminent physical injury or illness is more likely to occur. So that's a pretty specific definition, and more importantly, there has to be a judicial determination. So in a lot of cases, this might not be the definition you want to use.
Not in your business document. It's a very high standard.
Let's look at some other definitions. Black's Law Dictionary defines it as, it means that a person cannot perform their usual functions or duties due to a mental or physical disability. Probably getting closer to what you would be worried about if you were running a business. Just the Webster Dictionary online definition is lack of physical or intellectual power or of natural or legal qualifications. Wow, that's can mean a lot.
Yeah.
So that's probably not going to be terribly helpful if you use that definition either. We certainly recommend that you define it in any kind of documents, because as you can see, that word can mean a lot of different things depending on the context. All right, so what are some solutions that people look to in planning to plan for incapacity? They may have prepared durable powers of attorneys, a healthcare surrogate designation. That's pretty common in estate planning matters. However, probably is not going to be sufficient to help you in the operation of a business. Just because you may be made your brother or your wife your power of attorney and healthcare surrogate designation to make financial decisions, personal financial decisions and personal health decisions, they certainly can't step in usually, in most cases, and be a principal of a company or manage assets. Trusts are a way that actually people try to get around incapacity issues. They try to plan for the day that maybe themselves, if they're managing their own trust as trustee, or if some other trustee becomes incapacitated, how they can step down and just someone else goes in, so there's no disruption. Finally, if you haven't done any of these things, usually the only solution is guardianships. That's usually a pretty burdensome solution. It requires obviously court filings, court intervention, court supervision of a guardian. It's costly. It's not, certainly not time efficient, and it's probably not helping the business operate in the interim who's experiencing these kind of issues.
Teresa, if you could go back a second to the durable powers of attorney. Is there, again, this is not in my practice area, but I'm wondering if there's something in that document which triggers, you know, if someone else to step in specifically, and whether that could be a potential trigger or cross-reference in the corporate documents for a business if somebody is an owner of a business.
Yeah, that's a good question. You know, most powers of attorney, they're very general in nature, and they're effective immediately, whether you're actually suffering a true incapacity or not. If you're just not available, someone can go in your stead. But there's certain, you can certainly have language in there that says, and they used to call them springboard, that they don't start until there's some kind of incapacity that's been determined by a certain definition, whether it be a doctor's, review or things like that. And and this will come up a lot, a reoccurring theme. One of the things that you and I have noticed people like to do with incapacity and defining it, put it in documents, is they like to say, okay, well, if the person goes to a doctor, and sometimes they list a doctor, their usual family doctor, and the doctor determines they can't perform their functions, then for the purposes of this document, they're determined to be incapacitated. One of the key problems with that in practice, though, is how do you make a person go to a doctor? They can't be forced to be subjected to that, subjected to an examination. They can't be forced to reveal the results of that examination. They have HIPAA rights in that, at least not in a civil context, not in a business context. They can't be physically forced to do that. So sometimes that's not the best definition or the best springboard event, so to speak, to use if you want to trigger certain events. And we'll get more into that now with our third section. Let's look at some incapacity contractual provisions, Kathryn.
Sure. Then the next series of slides contain some sample provisions that we have seen in business legal documents. So these are, you can find these in operating agreements or employment agreements, where the status of permanently disabled or incapacitated triggers some consequence. And so in the operating agreement realm, that consequence may be if somebody is permanently disabled or incapacitated and they're no longer to serve in a management role, for example. That could trigger a buyout of their equity shares in the business, which is a separate, you've got a couple hats. You've got the manager hat, and then you have the member or equity holder hat. And the way they connect is if for some reason somebody is not able to fulfill their management duties, the other partners may want the ability to purchase their equity, or that person who was affected may want to be able to get out and liquidate their position. So in the operating agreement context, you'll see a buy-sell provision whereby you have an event like a disability, and then a series of options may kick in for the company to buy out the affected person or the other members, and it provides for payment terms and an orderly exit upon the occurrence of the event. But the practical aspect of that is, okay, well, what does it mean to be permanently disabled? And in your contracts, you can provide, there's really, no limit as to how you can define these types of events, but we do have to keep in mind the practicality, like Teresa had mentioned earlier. And so in this first example here, the operating agreement makes reference to a the disability standard that's set forth in a disability insurance policy. So if you have a principal that has a long-term or short-term disability policy, that policy may have a definition of what it means to be permanently disabled for purposes of drawing benefits from the policy. And so this may be used as a proxy if people want, some kind of objective standard or relatively objective standard that isn't drafted by a third party. We could certainly have that in place and referenced in the operating agreement. But again, the issue comes up with what if the policy lapses, or what if the policy isn't in place at the time of the event? And so that has to be considered when relying on third-party documents as your source for definitions.
And I guess I could see some situations where maybe someone's not permanently disabled enough by the definition to for the policy to kick in, but certainly maybe showing some incapacity or some dementia that maybe they're not the key. You don't want them to be no longer be the key person,
right?
Or the person that's representing the company or managing the company because of those issues, and there could be a big gap in between.
Right, right.
So that might not be always the best definition. I agree.
The second, this is a lot of words here, but this is really a very formal, structured determination of disability that involves a medical panel. And mechanically how this works is that there is some period of prolonged inability to perform normal business functions. In this language here, it's a continuous period of 45 days or 65 days within any single continuous 120-day period. So if somebody is not able to perform the regular duties for half of 3 months, for example, that would trigger the managers to be able to make an initial, decision that, okay, there's probably an issue here. Let's give this person notice. And then after that notice is sent out, the panel is the side. So the company on one side and the affected member on the other would select a physician. The physicians would get together and try to make a determination. And if they can't agree, then you bring in a third person. This is very formal. And as you can imagine, there's a lot of costs involved in having to round up 3 doctors and try to get them to agree. And the doctors may not want to be in the position to make that decision, because it is a big decision whether or not to remove somebody as the head of their company, or at least put them on the sidelines for a while. Is something that a physician may not be comfortable doing.
I know in the few times I've seen this come up, in every instance, either the doctor that was pre-selected or the doctors that were contacted didn't want to have anything to do with it.
Right. And so I think there's a lot of clarity in this definition. It gives some concrete periods of time where actions need to take place. And if people are willing to abide by that, that's great. But the downside is, what's good at time point A may not be good for somebody in time point B. And so you have to account for passage of time. However, it does give you some pretty clear guidelines as to how to enact or to initiate the process if there is a problem. This provision here is somewhat less formal in that, the managers or the other people involved in the company make a decision. They decide if somebody is permanently disabled. There's no need to bring in physicians or force somebody to subject to a medical examination. The company's if you have other people who are involved in the management of the company, it's made by the company, the others in their sole discretion, and really the only challenge to it is if it's just completely off the wall. The court finds that there was no basis for it. While this is very flexible, there is possibility for manipulation here. If you've got 3 management personnel, for example, and 2 of them just would like to see the other one retire, there's a lot of problems here because the 2 of them are outnumbering the third person. And if they are causing the company to make the decision, you have to really trust that they're going to make that decision fairly with this kind of language.
I know just from in the guardianship context, when there can be a period of maybe not totally incapacitated, and I presume the same here, permanent disability, but there's certainly a period where you're starting to fail. Your memory's going, maybe your focus is going, your concentration's going, your ability to retain information and make decisions is certainly being compromised, but it's not all the way gone. You have your good moments, maybe just a few moments, and I see that in the guardianship context where families struggling with what to do. I can only imagine in a business context what other partners and other maybe members of the board or other people that are principals are struggling with and trying to find if they've essentially reached that point where something should happen against someone's will, essentially.
And contextually, where you see this is you're a business where somebody has the majority interest, or there's somebody who is in the position to make that determination without really having to convene a lot of people. and so, this, again, we're not saying that any of these are one or better than the other in any context. It's just you have to kind of think about what the business what the goal is, the personalities involved, and what language may fit best for your circumstances.
Mhm. And of course, you're trying to speak to a client and get them to think about a time period that they probably don't even want to imagine or are going to believe that will never happen to them.
Right.
So you have that added burden too.
The next two provisions here are in the employment agreement context. And so, it's not necessarily an owner of the company, but sometimes the owner is an employee, and then a termination of employment or a disability finding under the employment agreement would trigger, the buyouts and things in the operating agreement that would affect their equity position. So here, it also, in the employment agreement context, it could affect whether someone is terminated for cause or without cause. There may be different consequences for cause versus without cause terminations. And so sometimes the disability or the status may have an effect on severance and other things under the employment agreement. So in this first slide here, the company can terminate employment without prior notice if there's a death, adjudication of a competency, or a permanent disability. We talked earlier about being adjudicated incompetence, a very high standard, and Teresa can speak to this. That's how difficult it could be to get somebody adjudicated incompetent. That's a lot of rights that are being taken away, so there's due process involved in making that finding. Again, you've got the permanently disabled. That quoted language is again, you can define that any way you want. Typically, it's if the employee is unable to adequately perform their duties and the condition appears to be permanent. Again, a lot of discretion. There's no requirement to have a doctor weigh in or have a medical opinion. It's based on the judgment of whoever is making the termination. So from the employer standpoint, you're going to want some flexibility in being able to make that decision. From the employee standpoint, and again, a lot of this depends on who you're representing as a lawyer, how you draft it. But on the employees, from the employee's position, if you're representing the employee, you may want to write it, request language that says, okay, you're going to use reasonable discretion. There's going to be some form of basis. You don't want, an employment decision that is on its face motivated by the inability to perform duties, to be able to cut somebody out of something unfairly. So that's always a concern from the employee's standpoint. And then the next point E here does involve a physician to look at it, but it's the person, but it's the attending physician. So somebody who may have already had the relationship with the employee. They're not brought in specifically to make a determination for employment law purposes or for the contract, the business agreement purposes, but this is somebody that may have already had the relationship with the patient and maybe a little more sensitive, I guess, or attuned to the individual who they're examining.
Mm-hmm. Yeah, I was looking at that definition. I would presume is more like the condition, keeps them from adequately performing his or her duties. And that would be easy to get from the attendant physician, but getting an opinion as to more likely than not to be permanent might be a little more difficult. I experienced, physicians treat. They don't want to go on and then make an opinion as to
they're in the moment, right?
And the prognosis and make something that is going to determine if someone's going to get fired or not,
right.
Essentially, as to whether this is going to, how long this would last and things of that sort. So that's interesting about the employment context, because as you mentioned there about the adjudicated incompetency, it's important to realize when the legal community, the judiciary, is making a determination of incapacity, they're determining whether you can't do the functions at all, not whether you can do them well or as good as you may have used to do them. As long as you can somewhat do them, even if it's poorly, that's not going to get you a legal incapacity standard. But obviously an employer is probably, even if you can't do them as good as you used to do them, that might be concerning to them, depending on what how important the functions of the job are.
Teresa, have you ever seen cases where, somebody may be arguing that the person is incapacitated or diminished, but it's really maybe a business decision that wasn't agreed upon, and they're trying to kind of use that as a guise to undo a business decision?
And that's one of the conclusions as you and I went through these materials that we kind of came to, is that sometimes the guardianship or other, things like that are used because people didn't plan for this event. The person is probably not legally incapacitated, but they're suffering dementia, or they're suffering some kind of issue that's certainly taken them down. They're not at the level they used to be. Anybody who deals with these issues will tell you when folks are in that kind of transitioning period where they're declining, they don't want to admit it. They can be very stubborn as part of the illness, and they don't see it, and they will not admit that there's anything wrong with their memory. There's nothing wrong with their ability to focus and analyze and retain information. And they get very defensive and sometimes very angry, which can make them hard, even make it more disruptive for a business or harder to work with them. So people try to use that to kind of substitute because they didn't plan it out and didn't contractually decide beforehand how it would be handled. But it doesn't work very well because, as the judge will tell you, my standard is they can't do any of these functions at all. I don't care if they're not doing them as well as they didn't do them. That's not going to take their legal rights away. So one is not a good substitution for the other, definitely.
We have a question listed there. I'm not sure if you addressed that.
I do see the question. It says, do you see a circumstance wherein husband and wife execute durable power attorneys for each other? I'm not sure what they mean in the context of what we're talking about today. Husband and wife certainly do that. They put each other as their agent in fact and powers of attorney and durable powers of attorneys. I don't know of circumstances in a business context where a wife could substitute in as a husband, as a shareholder or a member or someone who's going to actually have control and voting rights and stuff. Usually that's not going to sit well with the other.
Right. And I could see a situation where maybe somebody has a very broad durable power of attorney that allows the wife or husband to step in. But the operating agreement may not permit that or may expressly say you can't do that. Or if it's silent, then you have to figure out, okay, well, does one have any bearing on the other? And I think that's an interesting issue is, if you've got a durable power of attorney that the other members of the company are not they're not parties to, can they be bound by that? And do they have to honor it? And if that's a situation where you already have a durable power of attorney in place and the person who is granting the power is involved in a business, that may be something you need to discuss with the business partners is, okay, I have this in place as part of my personal planning, how is it going to bear out? And if it's a particular concern where if the husband and wife, if the wife is very involved in kind of or the husband behind the scenes is to the decision making and helping that person in the business make their decisions as manager of the company, they certainly may want to see that power extend into the organization if the durable power of attorney is needed. I know DPOAs, they have some broad language that allows whoever is stepping in to transact shares and participate in management, but again, that may not necessarily be binding.
No, it may not be binding, and it may not be the best interest of the company either. If you have people coming in who aren't experienced in the area and things of that sort, and even if they're doing something like voting shares, it can be disruptive. We see this in the guardianship context. Guardians, be they lay people or professional guardians, sometimes are put in charge of the person's all their property, and they inherit a small, there's a business with maybe another partner, and all of a sudden they're expected to act as if in the stead of the person who's incapacitated, and they don't know the business, so they're in the position of either dependent on the other partner or trying to find someone who does and get either consultation or put them in as sort of a replacement. So it's probably, except maybe in rare circumstances where the husband and wife both are involved in the business, it's probably not going to help in the context of trying to lessen the disruption and negative consequences of the incapacity issue. So with that, and please keep the questions coming, let's move on to section 3 of our agenda today. Incapacity contractual provisions, and trying to show where they may be insufficient in different contexts. Kathryn, I know this is something that you probably see a lot in your handling of agreements.
Yeah, we do. We try to plan for them, but again, it's, and we'll talk about this a little bit later in certain scenarios, but your operating agreement, if it doesn't address succession, if it doesn't address who might step in, that can have a ripple effect into your third-party agreements. And so in addition to defining what a permanent disability might be, you may want to have discussions internally as to who might step up to the plate if somebody were to fall within that definition. And you may have ways to contract so everyone's on the same page as to what the succession plan could be. Again, and not necessarily might not be in the documents themselves, or maybe within the organization, preparing the right people, having discussions with them early on, kind of getting them on board to step in the shoes of a founder if there is an issue. And I can tell you, we could draft all the documents in the world and craft them, but if there isn't a discussion at that level, the person may not be prepared, or they may not understand kind of what they're getting into, regardless of how tight or how lengthy the documents are.
No, and I think sometimes these provisions that we're looking at and that you see a lot of times, they presume the person who's maybe having the incapacity issues or the disability issues are going to be cooperative, or at that point in the future, they may not be. You can't, you'll have a nice conversation today. That's why it's good to put the intentions and the purposes and the means in writing, because for the example I gave earlier, depending on the nature of the disability, if it's a mental deterioration kind of disability or incapacity, the person, they lose the ability to sometimes to be cooperative, to perceive things correctly. So they'll feel attacked and things of that sort. So, and I've heard people say, well, I'm sure when that comes, we'll just sit down and we'll talk about it. Don't presume that you'll be able to have a good, productive conversation at that point. In trust, just to give you an example of what I've seen in trust that I deal with a lot more than the operating and shareholder agreements that are more in your wheelhouse. I see incapacity provisions a lot, and again, it's kind of a similar issue, because usually it's dealing with age. It's usually a spouse or someone personal or close that's going to take over if they don't want to accuse the person of being incapacitated, or seeing them slipping, and so sometimes you may want to give that some thought and wonder if maybe that those are good times, your successor trustee maybe to be a third party, a professional, someone who would not be torn between their wanting to do right by the trust and do those kind of things, but also torn because of their relationship with the person who's going through the incapacity and not want to make it worse. And I've just had a situation recently like that. So sometimes maybe it's good to ask if they really want to be in that position where they have to kind of say, here's a letter finding you to be incapacitated and you need to be removed as trustee or something of that sort.
And in the business context, the reality is you may not have somebody who is wanting to kind of take over in a founder's role, and in that case, you could also, if it becomes clear that there may not be somebody within the family, for example, who wants to step up, then you can make decisions on whether or not you want to sell or however succession planning is going to work. It's good to know that either way. So if you need to position your business for a sale, there's all these steps, and we talked about it in prior seminars as to how to prepare your business for a sale. So that would also be, even if you don't have somebody identified, it's a good exercise to go through so you can make a decision as to how to deal with the business in the event somebody does, the founder is in a state where they're incapacitated and no longer willing or able to run the business.
Did you have anything else to add on B?
So on this one.
On C, just going through the possible damages and consequences, I think we've kind of talked them out, and you can extrapolate from here. But remember, what we're trying to do here is mitigate. There's always going to be negative consequences if someone's who's been key to your company or who's managed the assets of a trust is going to be taken out. There's going to be some disruption. We're trying to minimize that. We're trying to keep. I think usually the goal is to keep the legal system out of it. You don't want to have to go to the guardian. You don't want to have to go to the guardianship, as a last resort. Recognizing that you may have some, some additional costs related to maybe some legal, or medical, examiners and things of that sort that you need to do. But you certainly don't want to take on the cost and the inefficiency of a guardianship. But more than the monetary, I would like to emphasize again that some of the damages can be relationships. Some of these people in partnerships are small, closely held companies. They're either, if they're not family, they're friends, lifelong friends. And so if, to the extent that these things are in writing and more clear, it probably helps with keeping the relationships intact so someone doesn't feel like they've been attacked. So let's go through some recommendations for better documents. First and foremost, I agree with what Kathryn said earlier, sitting people down and understanding the personalities that are in play, getting them to talk about this, getting them to imagine the scenario, even though they're not going to want to, is probably the first key thing you can do in drafting better documents. What else do you think maybe you might start
We
from
talked
there.
about the definition of incapacity and permanent disability. Again, we gave you some, examples of language, which it's not definitely not a one size fits all, and I think that's where the discussions come in. Again, the method on who you choose to remove and replace a successor, not just in a practical day-to-day, concern, but banks and creditors, they're going to want to, they may prevent you from putting somebody into place if you want to put into place, or they may call an agreement to default if they don't like the person you put into place. So we'll talk about that in the further point below. And then again, a successor plan in place with a person named. That's kind of your best case scenario if you have somebody in that position, maybe a generation behind the person who's a founder, who's had experience in the business. But if you don't have that, then you can kind of pivot towards a potential sale of the business in the event of a decline. If there's nobody who is willing to kind of carry it on from there. Here on the successor, our firm does a lot of commercial loan deals representing borrowers. We also do franchise agreements where we're representing the franchisee. And in relationships like that, those documents tend to be very onerous and very friendly to either the bank and the loan situation, or the franchisor and the franchise situation. In these documents, the bank document that I'm thinking about, there was something buried in the covenants in a 200 page document that caused a technical default in the event, founder X was no longer able to work for the business, that they were no longer in a management role. And even if there's not a monetary default under the loan documents, a technical default is there, and not that the bank would necessarily call a loan into default, but it does create leverage that would permit the bank to perhaps renegotiate some terms that would be more favorable to the bank. So in the credit agreement situation, if there is a default because a founder is no longer in that position, the bank may require additional collateral that they didn't have before. They may feel insecure, which is, I've seen that in documents, they're not comfortable, or they feel insecure. It's a very nebulous standard. Mm-hmm. So it just gives them the ability to ask for things that they may not have wanted or thought to ask for when the original agreement was being negotiated. So how we deal with this is that you try to negotiate upfront, who is going to be an approved successor. That way, if there is a problem, you've already had somebody identified, or at least you have the criteria identified, which if the replacement, the successor meets that criteria, the bank really can't withhold their discretion to approve that person. And so in the deal that we were working on within the last few months, we negotiated the ability of the borrower to appoint somebody with XYZ qualifications, meeting those qualifications, and the bank really had, unless that person did not fit those qualifications, the bank really just couldn't say no without a good reason. And so that helps kind of diffuse a situation where the bank, not that they're going to want to protect themselves. And so if there's a situation, the business is already going to be disrupted because of the founder's inability to continue in the capacity, you don't want to pile on and have the bank be able to create additional strain on the business to do an event that's really not in anyone's control. And the same thing in the franchise situation. The franchisor may have vetted a particular individual. That individual may have had a proven track record with franchises, and they put a lot of faith in that person for the success of the business. And similar situation there, you don't want a franchisor to be able to pull a franchise or create a default or call a default, at least not without having a reasonable basis to deny a replacement or a successor.
Well, as we went through that, I think some of the important things I'm taking from this conversation, Kathryn, is that one, people have to think about it and they have to plan for it. And I think the statistics we looked at in the beginning reminds us that these events could happen when you don't expect it. Don't start the planning at 50, 60, where most people start really thinking about, transitioning in estate planning and things like that. if you have a business, if you have any kind of enterprise where you're a principal and that you're a necessary party or at least an important party in that enterprise, kind of step out of yourself and say, you know, if I'm unfortunately one of the statistics, the 1 in 7 or something else that we looked at, how can I plan around that and do some of these things like you mentioned? How do I make sure that maybe if I'm grooming my 20-something-year-old son or daughter to take over the company, but they're a little young, and I know the franchisor, they're not going to be happy with a 27-year-old being the primary person. So maybe I can start using them as a contact person, and or think of someone else instead of just saying, well, that's probably not going to happen until much later in life. This is something that people should be planning much earlier. We always emphasize to clients, start your estate planning early. Don't wait till you're looking at retirement down the road. Start it early. You have to plan for the unexpected. I think the same has to be said with incapacity and disability issues, in all facets of life, but especially when it comes to a business, because you can inadvertently disrupt the business to the extent that you could have such impact damages that maybe the business doesn't survive.
And once you have a plan in place, revisit it. Something that may work for someone who's 35 may not work when they're 50 or later. And so once something's in place, see how, just, it's good to have it there, but revisit it periodically. If there's a personnel change or a marriage or a divorce or any kind of big life event, there's a lot going on, but another thing that you may want to add to the list of things to revisit is your business succession and looking at your business documents just to make sure they still fit your circumstances.
And unfortunately, I don't think you can always take estate planning and business planning and separate them.
Right.
They're entwined. Spouses are going to want to know what happens to this closely held business that supports our family and pays our bills. Right. And if you've had discussions with your partners and there's a structure set up in the case of disability, death, what have you, that's going to continue the operation of the business maybe without the input of the spouses. Those things need to be discussed in hand, because otherwise it could cause even more disruptions if the spouse feels like they're being ousted and they didn't know about all these provisions and stuff. Again, to wrap up, because I do so much in guardianship, what you don't want, I can't think of a circumstance where guardianship is going to be beneficial in a business context. In addition to having to go through the public, spectacle of an incapacity hearing and determination, again, the people that are put in charge of the guardian's property, they're either, a personal person with a close relationship, or in the case, sometimes a case, professional guardian. Just because they're professional guardians does not mean they're professionals that operate in a business, or they can just step in the shoes and things of that sort. And same thing with trustees in the context of trust. Sometimes, I'll have a quote unquote, corporate trustee. Well, that doesn't mean that when there's something so personable about the management of your company and things like that's a good solution. So again, I think what we've discussed about these contractual provisions and planning is the good part is that the person has some say in how that's going to be handled, and can determine what's best for their individual situation.
Thank you all for attending. And if you have any questions offline, please feel free to email us or give us a call. Thanks so much.
Have a good day.